Right, welcome to all of you who have joined. I'm just waiting a few seconds so that maximum number of people who want to join promptly at the beginning can join. The numbers are going up, I can see from my screen, and in a minute we'll make a start. Right, I think we should probably make a start now. So good afternoon to everybody who is watching this webinar. You're very welcome. The format of today's webinar is that I shall be taking a chairing role in it, and I'll be throwing some questions to the four participants who will deal with the matters which I ask them about. We have on the panel today Rhys Taylor, Emma Hitchings, Beth Kirkland, and Jonathan Galbraith, all well-known figures from the world of pensions on divorce, all of whom have been very much involved with the work of the Pensions Advisory Group and the production of the reports, and in Beth Kirkland's case, the recent Advice Now Pensions on Divorce report as well. So we're going to start off by discussing the Pensions Advisory Group report. For those of you who have not seen it, there's a paper version of it, which I'm holding up now. You can also get that online by downloading the PDF at the www. Nuffield Foundation site. It's readily available, freely available to everyone. It's similar in its presentation to the PAG-1 report of July 2019. It came out at the very end of last year, or the early part of 2024, so it's still very fresh. And I'm going to turn for my first area of questioning to Rhys Taylor, who's an important member of the Pensions Advisory Group, to tell us about the process involved in PAG-2, what is new in PAG-2, which wasn't in PAG-1, and what readers of PAG-2 should be particularly looking at. Rhys.
Thank you, Edward, and good afternoon, everyone. Quite a lot has happened since 2019 in the world generally, and also in the world of pensions on divorce. And so we thought that it would be worthwhile to try and update the report. In fact, we probably bit off more than we were expecting, because a lot of the arguments which we thought we put to bed in 2019 reopened themselves. And so there was another very thorough look at all of the issues. But just cantering through some of the key headline points, there's of course been quite a bit of case law about pensions on divorce since the 2019 report, and there have been cases both at the circuit judge level and the High Court judge level, sometimes taking a bit of a different approach, and so those are wrestled with. We've got the Galbraith tables, which are a way of, in a rough and ready way, being able to value the gross value of a defined benefit pension. And although they weren't part of the work of PAG-2, we've run a slide over them, and they get a cautious welcome from us as being a useful tool, and we'll talk about those in a minute. Those of you who have been following the politics recently, aside from what's been going on the beaches, there's been news in the last few days that the Labour government, if we get one, is not going to reintroduce the lifetime allowance. The background to the lifetime allowance was that it was causing havoc in the NHS, and so the doctors were up in arms about that. And rather than having a discrete carve out for people in the NHS, the Conservative government have abolished it to all intents and purposes. There's one little holdover in respect of it, which we might have time to get to, but that's been quite a complicated process dismantling it. And those who were involved, I think, were despairing at the thought of it then being brought back in, but that doesn't appear to be the case. The issues relating to McLeod continue to bedevil public sector pensions, and we'll touch on that. You'll recall back in the day, we were able to found jurisdiction for people who otherwise wouldn't have jurisdiction to do with pensions in this jurisdiction, using the forum necessitas jurisdiction, and that's gone as a result of us having finally Brexited. We have new language with the Divorce, Dissolution and Separation Act, and also a revised template order in the suite of financial orders. And we'll take you to a slide when Jonathan is speaking in a little while, just to show what a wild time pensions have had during the premiership of Liz Truss. So there's been quite a lot going on with pensions on divorce, and we've tried to capture all of that in the new report. There's on the Nuffield site, there is a detailed list of how PAG 1 has changed from PAG 2, or rather how PAG 2 has changed from PAG 1, in case anyone is inclined to train spot the differences. Sorry, Edward, did you want to say something?
I was going to say apportionment was one of the issues which arose after PAG 1 as a result of various things, and PAG 2 deals with that. Tell me about that. How's PAG 2?
Yes, and I was just coming to a decision of a certain circuit judge, His Honour Judge Hess, in the case of SP and AL, and this is now the key case to go to for pensions on divorce, 2024, England and Wales Family Court 72. And what the court does in this very recent case, it has a look at PAG 2 and makes some observations, including about apportionment, which I'm going to come to in just a second. Very briefly, this is a marriage of 9 years later on in life. It's second marriages for the parties, and by way of apportionment, if it was equality of income, it was 9.2% of a pension, quality of capital 10.2. Not a huge difference between those two outcomes. But this was the first time that the PAG report got to be considered post its publication in January. And I think perhaps being inspired by Mr. Justice Mostyn, who I'm told was also, for his part, inspired by Nina Simone on Desert Island Discs, having selected all of her own songs. His Honour refers back to one of his earlier decisions, and the well-known case of W&H, which we've all cited ubiquitously over the last few years. And it won't come as a great surprise to find that the court is satisfied with the way in which the status of the PAG report was articulated in W&H. It was noted as having the support of the Family Justice Council and the President of the Family Division, and as being prima facie persuasive in the areas it's analysed, although of course susceptible to judicial oversight and criticism. His Honour goes on, I'm not aware of any subsequent judicial departure from this proposition, and I would suggest that it stands as the proper approach now applying to the second edition of the PAG report, published in January 2024, often known as the PAG 2 report. The case is most definitely worth reading. It goes through all of the usual debates about pensions, but in the time that I've got this afternoon, I'm going to focus in on paragraph 40 and the question of apportionment. Is it appropriate to apportion? And His Honour refers to the PAG 2 report, saying generally in a needs case, it would be wrong to apportion pensions so as to exclude the non-cohabitation marriage element. By contrast, in a sharing case, where the assets and future pension benefits exceed the parties' needs, such apportionment may be appropriate. But then it gets interesting. But the report goes on to suggest that the categorization of a case will depend on other Section 25 factors, most obviously the duration of the marriage. Those of us who were involved in PAG 1 are a little bit stung about some of the criticisms we received, the suggestion being that we'd said in cases, however long the marriage, and there should be equality of division. And PAG 1 didn't say that. But we've gone out of our way to make sure that we can't be misinterpreted on this occasion. So the quote goes on, thus the court will have regard to the length of seamless cohabitation or marriage when determining the extent to which it is fair and reasonable to divide the non-matrimonial element of any capital or any pension. All cases will be determined on their own facts. The marital element of any pension will usually be shared equally. For the reasons set out above, in a needs-based case, the timing and the source of pension saving is not necessarily relevant, but the court will nevertheless have regard to the length or shortness of the seamless cohabitation in marriage in determining the extent to which the needs of the claiming party will justify a division of the pre-cohabitation marriage element of the pension. The requirement of a nexus between the relationship and a financial need to be met by a matrimonial claim has been long established in case law. And so I think paragraph 40 in that important case is the one which will be ubiquitously cited in the months and years ahead as we wrestle with questions of apportionment. And so yeah, I think that's probably a neat summary of where we've got to with
Rhys.
PAG 2.
Just a follow-up question. What's the feeling of PAG 2 about big money cases as opposed to medium or small money cases? Is there a difference of approach?
Yeah, well, I mentioned that the case law is diverging in that respect, and we try to capture that in PAG 2. The most obvious High Court case that comes to mind is the case of CMX. And in CMX, there's assets north of 20 million. And so it doesn't really matter about the finer points of understanding the value of £1 million pension or £2 million pension for that matter. It's not material to the outcome. And so there, if there is a difference in approach in the big money cases, much less interest in calling upon the likes of Jonathan because it's just sort of something that's swept up and it isn't holding the balance of fairness in the case. In contrast, in cases before circuit and district judges, the value of a pension will often hold the balance of fairness in the case. It matters where the house is worth £400,000 and the cash equivalent of the pension says it's worth £400,000, but it's really worth £500,000 if you had to go out and buy those benefits. In those circumstances, many people would say, well, I want that aspect of value brought into account. So I think that the difference between the big money and the small money cases is that in the average money cases or ordinary money cases, whatever you want to call it, is that the pensions are looked at more carefully at the circuit and district bench.
Well, thank you very much, Rhys. And I should just say to everyone, if you wish to ask a question, the chat bar is open, and we may have some time at the end for a few questions from that. But I'm going to change the tack now, and I'm going to ask Emma Hitchings to talk to us about a different document which she's been very much involved with, the Fair Shares report, which has a section on pensions on divorce. Emma, what does your research tell us about what's going on in the world of pensions on divorce?
Thank you, Edit, and good afternoon, everyone. For those of you who actually aren't aware of the Fair Shares research, which was funded by the Nuffield Foundation, the report is the first representative study in England and Wales of how finances and property are divided on divorce. So for this research, we developed a survey which was completed by just over 2,400 divorcees, who had been divorced in the last 5 years. And this was supplemented by a range of in-depth interviews to provide both quantitative and qualitative data for the study. So we actually had a range of findings in relation to pensions on divorce. I think one of the first key findings was the level of pension wealth on divorce and how this is particularly gendered. There is a really stark picture of women being more likely to have a lower value pension than men. So, for example, in the study, for example, with men with pension pots, 13% had a pot worth at least 300,000 compared to only 2% of women. And I think what this highlights is a particular financial vulnerability for women. Their lower value pension pots are likely to impact on their financial security in retirement, particularly if they have taken the main responsibility for childcare post-divorce and are unable to make decent contributions to a pension scheme over the coming years, of course, speaking to their ongoing needs. The second key finding relates to a lack of financial awareness amongst divorcees, particularly in relation to their pension. So the research found that just over a third of all divorcees not yet drawing their pension did not know the value of their own pension pot. And of course, these individuals had gone through the divorce up to 5 years previously and should be, hopefully, have some awareness of value of pension, but they didn't. Over a third of divorcees did not. And we found as well that women were more likely than men to say that they did not know. So what this lack of awareness and understanding in pensions fed through, as one might expect, to how, if at all, pensions were taken into account when couples sought to make their financial arrangements. So that was a second key finding. The third key finding is that overall we found very low levels of pension sharing. In only 1 in 10 divorces where someone was not yet drawing a pension, was there an arrangement for pension sharing. Now, the reasons why pensions were not shared came through from the interviewees, and interviewees often expressed the view that pensions are personal to the individual who is making the contribution. So it didn't feel that this was an asset that could be shared. And this strength of view that pensions belong to the contributor, coupled as well with a need and a wish to resolve the matter of housing for the couple and any children, meant that offsetting was the preferred alternative for many divorcees. However, offsetting does not adequately redress the differences in divorcees' living standards in the years following their divorce. And we found again that up to 5 years after a couple's divorce, that being a parent, especially a mother, and being older, especially an older wife, was associated with greater financial hardship in terms of the amount of income that was received up to 5 years after the divorce. Therefore, you could say that there is an argument that the recipient of an offset is at a potentially longer term disadvantage to the pension member by not having the equivalent amount of pension fund going forward. So I think overall, what practitioners can take from the research is it's clear that both parties to a divorce need to be made aware of the potential importance of pension wealth as part of their entire asset pool, and that also couples going through a divorce still too often misunderstand or overlook pensions, and pensions are also still wrongly considered by couples themselves to be the property of the party who generated the pension fund. And that ultimately pensions are absolutely vital assets, vitally important assets that should not be overlooked, especially in cases where wives particularly are more concerned with their immediate capital provision and should be reminded about their longer term income needs.
Right. There's a question in the chat box saying, should judges do more to make sure that parties are aware of the values of their pension? Would you agree with that?
I would say that ultimately, I think consent orders that are going through that have been agreed by the parties and look particularly unfair, and that pensions are an obvious asset, there is a case for the judiciary at that point to halt the process and actually send that application back for reconsideration to say, look, there is an enormous asset here with a cash equivalent value, and potentially this is something that needs to be considered. I think if we look at particularly the case of Lewis and Cunnington, the Cunnington case, where of course here it was with regards to the police pensions, and that it was obvious that that was a substantial pension and potentially 15% of the assets there. So why was it that that consent order was not sent back at that particular point? So I do think there is a potential issue for the judiciary to look at consent orders with regards to pensions.
Yes. Well, I know that quite a few do get sent back for exactly that reason, but perhaps not enough. We need to be aware of that. Are you going to do some more work on this in the future? Any plans?
Yes, I think, well, the short answer is yes, we're doing some more work with the Fair Shares data set, although not specifically pensions focused. We're looking at we've got some further funding from Nuffield to look at three particular aspects. First, the public understanding of the law around finances on divorce. We have as yet an unanalyzed data set of over 20,000 adults where we'll be looking at the public's understanding of the law around finances and how this varies amongst different population groups as well. We also want to look at domestic abuse and financial remedies. I think domestic abuse and financial remedies is an incredibly important issue that has come to the fore in recent years. So again, we're looking and planning to examine data captured by the survey to provide a detailed picture of domestic abuse and financial remedies, particularly the experiences and outcomes of domestic abuse survivors who have gone through a recent divorce. And then the third element that we're planning to look at is on financial outcomes, two particular aspects: the interaction between child arrangements and financial settlements, and also regional disparities in financial provision, spousal support.
Good. Well, thank you very much, Emma. That's a very interesting account of your work. And I'm now going to turn to Beth Kirkland. Now, Beth is involved with Advice Now, which has produced a report, the Updated Survival Guide, which is a slightly differently presented form of the Pensions Advisory Group report. So, Beth, tell us about your report. Where can we find it? How does it relate to PAG, and how would you recommend that we all get to know it and get other people to know about it? Beth.
Thank you. So it was also funded by Nuffield, and you can find it on the Nuffield project page. But for our website users, it's at advicenow.org.uk/pensions. And I can share that link in a moment. And it is very much aimed at the divorcing public, so the types of people who were surveyed by Emma and her colleagues. It is not aimed at the same audience, therefore, as the PAG report, and instead it really tries to support those people who have limited access to specialist legal advice, or only ad hoc access. So the focus of it really is to do some myth busting along the lines of Emma's research to really set out what the law is when it comes to pensions on divorce, and help people to appreciate and understand what they need to do if they are divorcing, and not ignore pensions or feel that they cannot consider them. And actually the law is there to protect their position going on into their future post-divorce. So it has a very significant element of awareness raising throughout, and it encourages people to seek legal advice and pension specialist advice if they possibly can afford to. But it is also very much aimed at the lower small money income cases. So it acknowledges that there'll be a lot of people who just simply can't do that. So to address that, there are practical tips throughout the guide and step-by-step journey on what people need to do to actually be in a better position than those surveyed often by Emma, who have no idea as to their pension value or the pension value of their the spouse that they're divorcing. So it's very much a sort of supportive and encouraging and empowering guide, hopefully, that's the aim at least, to take people through that process, but flagging as often as possible that they really should appreciate it's complex and they need to get other specialist advice where they can possibly afford to.
How many people do you think read the survival guide, or the non-lawyer people I'm talking about?
So across our family law pages, we have around 500,000 page views a year. So it's a considerable number of litigants in person who can't access the lawyers who are here today. And that's across our different family law guides. The pensions guide that we published with the help of Nuffield and PAG 1 has been just updated, so it was published at the end of May, and that reflects changes that the PAG 2 group discussed and ruminated over for several months, and but with a slant to make it more accessible for the kind of average divorcing couple. And yeah, I think you asked how people could use it as well. So that's LIPS. It's organisations such as law centres and law clinics. It's lawyers who can use it with their clients who maybe they don't have sufficient time to go through all the detail with them if they're only paying ad hoc advice. Or it's lawyers who are faced with litigants in person on the other side. They can signpost the people that they're dealing with who don't have professional advice to our website.
Right. And Rhys, you wanted to add something to that?
Yeah, can I just chip in with an observation? And I've said this at a number of lectures I've given over the years, contrasting the PAG report with the Advice Now report. And I can honestly say, having been involved with both of them, that if both were in the water drowning, I would dive in and I would save the Advice Now guide over the formal guide, because it's just so accessible. It just breaks open the complexity in a way which is just easy to read. And with what Emma was saying about people just not understanding what's going on, the force for good that the Advice Now document is profound, and directing LIPS to it, directing opponents to it, directing clients to it, it really has a fabulous reach in helping to dispel the problems which Emma has identified.
It's a nice thought of a drowning man having to choose between PAG 2 and the updated survival guide, but we'll leave that thought for the time being, and we'll take up a different subject. Thank you, Beth.
Thank you.
Which is to do with cash equivalent values, or CETVs, sometimes called. And Jonathan Galbraith is going to talk to us about this. I noticed there's a question in the chat bar, which is certainly something that I've come across in cases which I've dealt with. It's taking an awfully long time for cash equivalent values to be produced by the various pension providers. What's going on, Jonathan, to give us the update from the front line on that?
Very happy to do so. Thank you very much indeed, Edward. Yes, I don't have many slides, but I have a couple, and I have one that I'm looking to share now, if I may. So I hope that has appeared. Yes. So I'm kind of underneath it now. So what this is here is it's a tracker produced by an actuarial consultancy firm called XPS, and this is their best estimate of what a cash equivalent value of a defined benefit pension would be over time. Now, what they're considering here is it's an individual who has a £10,000 per annum pension that's payable at age 65, with this individual being currently age 64. So 1 year away from receiving this £10,000 a year pension. So it might be a bit small to see there, but we go back as far as May 2018. And as you can see, all the way up to November 21, it kind of bounced around a little bit, and sometimes it was up and sometimes it was down. And I think this spike here is, excuse me, when the pandemic kicked off. But despite the pandemic kicking off, you saw quite a lot of stability there, ranging from about 230,000 to about 260,000 as this valuation. Then it peaked in end November 21, and then started to fall and fall and fall and fall and fall and fall. And then we've got all this noise here, and this does date back to October September, October of 2022, which was the when Liz Truss was PM. Also, the Bank of England was doing some quantitative tightening around it then, which is also one of the reasons behind that. But you can certainly see that cash equivalents were falling. Why were they falling? It's because interest rates were going up, and that has the opposite effect for valuations of pensions. Effectively, what we're seeing is it is now less expensive to provide a pension in the future because higher investment returns are available than had been available before. Then things kind of stabilized again, but remain at this much lower level there. And remember, this line here isn't zero, it's 150. So it looks slightly worse than it is. But what we've seen is quite a reduction in cash equivalents. Now, I think we're now in a position, though, that this isn't too much of an issue from what it used to be, because we should not now be using cash equivalents that predate this change here. This is effectively something of a paradigm shift in how defined benefit pensions might be valued. They are now seen to be cheaper than they were hitherto. If you're using cash equivalents that go back to 2021, then they are probably invalid because, well, the most definitely invalid is that they're quite out of date. You will not be able to get that. The same pension will now receive a lower cash equivalent value than it did then. So it would be misleading to do that. But as I said, I think all these old ones have been swept out of what we're working with. So I think this is less of an issue than it used to be. So that's with regards to private sector pensions. For public sector CEVs, we actuaries, we PODs have been telling practitioners for years the valuations of public sector pensions fall well below the true value of replicating the benefits. Since last year, the actuarial factors that are set by the Government Actuaries Department have been revised, and these CEVs are actually now somewhat in the money. They're about 10% in the money. That is to say, the cash equivalent of an NHS pension or a police pension, etc., that's been produced in the last year is probably a fair value and then a little bit more. So that is a departure from where things have been hitherto. So that's where things are looking CV at the moment.
And what was the perceived delay in actually being able to get some figures out of pension trustees? Was that caused by this chaos in 2022, and has that now gone away, or is there another reason for that delay?
I think private sector schemes will, from time to time, be a bit slow to issue CVs. I think the markets are a lot more stable now than they have been, as we can see from the chart. So that shouldn't be a blocker. But there are sometimes delays with some scheme administrators, but I shouldn't really see that as a blocker. I mean, certainly with public sector schemes, you might be seeing delays because of the McLeod issue, but I think we're going to touch on that one shortly.
Okay, thank you for that. For the benefit of everybody, this meeting is being recorded, so you'll be able to watch this on the website at any time. So the slides which you've seen on the screen will be available in that recording, and perhaps separately as well. Any problem with sending to Jonathan, to anyone who would like to have a separate slide such as the one you've just put up? Is that all right?
If you go to if you search for XPS tracker value, XPS pensions transfer value, search for that and it will come up. You will easily find it online.
Okay. Right, so now that segues into thoughts about the Galbraith tables, which of course named after you, Jonathan. So tell us where they've got to and where you think or hope they might be going, Jonathan.
Thank you. Yes, not just a vanity project. I promise. My colleague Chris Goodwin and I came up with the Galbraith tables back in 2020. We'd very much been keen to respond to what practitioners had been saying to us, that wouldn't it be really useful to have some kind of rule of thumb guide for valuing pensions in the first instance, again accepting that there are many caveats associated with that need to be considered rather carefully, but can you give us some kind of ballpark rule of thumb guide? And so we went away and we came up with such a guide, and the whole purpose of the tables is to allow practitioners to place that ballpark value on pension rights, and that might well be at instruction stage. I mean, we see lots of instructions that ask us to consider offsetting, but it's never entirely clear whether such assets exist. Are you asking us to look at offsetting when there's never going to be the capital to do any offsetting? I think it's also really useful to understand what fraction of total wealth held by the parties is represented by pensions. And I think tables can be really quite useful there. So we launched these tables. How do we use them? I will give a worked example in but a moment. But the tables have been updated. There is now a new set of Galbraith tables. We're now on to version 2 of the tables. They were updated for that very reason. That chart I just showed you. Financial markets moved in 2020. In 2022. Not too long after we published, really. And it's one of these things that once the financial markets had moved, we then took the view that the tables placed too large a value on pensions. As I said, the effect of interest rates going up means that pensions might now be deemed cheaper to provide than they were hitherto. Again, that's why I see annuity rates improving. And so we felt the need to revise the tables off the back of that. Shameless plug, you will find there's an article written by myself and Chris Goodwin that appears in the upcoming edition of the Financial Remedies Journal. You will also find the new tables in the issues in the new edition of At a Glance that I think has been landing on our doorsteps just last week. And you can also find them on the Matheson Consulting website. But really just to give a quick demonstration, if I may, as to how we might use them, if I can share my screen again. It's that one. And oops, there we go. There we are there. So here's a work example. Now, apologies, the numbers I assume are not especially readable. This is really just to give a bit of an indication. Rather than explicitly to read them out line by line. So let's say here we have a case where husband is aged 50 and he's got a defined benefit pension of £10,000 per annum payable at age 60. Wife is a bit younger, wife is aged 40 and conveniently for the purposes of this demonstration has got no pension provision of her own. So how might we then use the Galbraith tables to carry out some offsetting calculations here to place a value on these pension rights? And again, I think it's very important to remember there's more than one way to look at this. Are we looking at this as in what is the value of husband's pension to husband? Or are we looking at what's the value of that for wife to replicate it? So one is, if you like, a capitals measure, the other is an incomes measure, as in a matching incomes measure of this. So if we were to value this pension to husband, what we would do is we would fire up the tables and we would then look at factors used for the valuation of pensions payable retirement male. Age at date of calculation, you go down the left-hand side there to 50. Assumed retirement age, you go along there to 60, and then you find the number that comes out there, and you'll find, you probably can't read it here, but it says 17.040. And that's effectively saying that every pound per annum of income costs £17 to provide, as valued by the tables. And so therefore, we might value a husband's entitlement there at £170,000. So he would need £170,000 to replicate that pension promise in retirement. On the other hand, if we're looking at more of a matching incomes approach here, and we're looking at what would it cost for a wife to replicate this, she is a lady, so we're using females tables. Again, still assumed to retire at age 60, but she is presently aged 40, so we pull out a factor of 12.903. And what we're then saying is that wife would need to be given £129,000 in non-pensions capital, again before any tax or utility adjustments, to allow her to replicate this pension. Why is that number smaller than that number? Because she's 10 years younger and can invest these funds for another 10 years prior to retirement. And that's what the thinking is. So that's just a quick worked example as to how do you run your finger across and find the answer in the tables there.
Right, that's very helpful. Now, Rhys, what would you like to add to that?
Yeah, just to chip in, that's very helpful, Jonathan. Thank you. I think the thing that family lawyers need to be careful about is the £10,000 a year. When we get our pension benefit statements, we need to be sure we're looking at the right figure. And in particular, let's say you've got a client who left their employment in 2020 or something like that, and they turn up with a document saying that they're going to get £10,000 a year from age 60, but the document is dated 2020.
Yep.
Then you're working with an out-of-date figure. And so the running your finger across a table, I'm sure most family lawyers can manage. The space for it to go wrong is misunderstanding the pension benefit figure, and you need to make sure it's up to date. And so, you know, if you're at all unsure about that, then pick up a phone to a financial advisor to make sure you're understanding the pension benefit table. The pension benefit letter. That's one point. I think the second point, just to mention very briefly, this is only to value the gross value of defined benefit pensions. So defined contribution pensions, they are what they say on the tin. And then once you valued a defined benefit pension, if you were using this, for instance, for offsetting, you would then want to make an adjustment for tax and an adjustment potentially for utility. Both of those issues are dealt with extensively in the PAG2 report. So it's a great tool, but it's to value the gross value of a defined benefit pension.
Yep, couldn't put it better myself. Thank you.
Okay, thank you very, very much. So we're going to move to a slightly different topic, which is McLeod, the McLeod litigation, which I declare myself as an interest as a party in that. What effect has that successful decision by the judges, for the benefit of the judges, what effect is that still having on public sector pensions generally, and the pensions on divorce situation in particular, Jonathan?
Well, it certainly made dealing with public sector pensions a lot more challenging than was the case hitherto. So yes, in short, this was to do with the way in which the new pension schemes, the 2015 schemes, were introduced in 2015. And in short, there was, I think the term used is, there's a bit of grandfathering going on there. Those who were closer to retirement were either exempted from or delayed from being affected by the changes that were brought in for everybody else in 2015. This was deemed to be age discriminatory, and so the thing then had to be revisited. But it's not as simple as just saying, oh well, we'll just put it back a bit and we'll just unwind it, because the thing that has to be remembered is that it's not axiomatic that the new pension schemes that were brought in are a worse deal than the old schemes. And you've also got those older members who might well have been better off had they been in the new schemes rather than the old schemes. Why is that the case? The old schemes are final salary in nature, whereas the new schemes are career average revalued earnings, with some of them giving a top up on top of that. So if you're in the NHS scheme, for example, and you're an active member and you're in this new scheme, you get an inflation link every year, but you get another 1.5% on top of that. That might be more than your salary's gone up. The old schemes had normal retirement ages of 60, but there was no uplift if you went at a later age. So potentially you were losing out in an actuarial value sense if you did actually retire at a later age. So it has to be remembered, these new schemes are not necessarily a worse deal than what they replaced. So what it's meant is, what the schemes have had to do is roll back service from 2015 to 2022, because that's the affected period, into these legacy schemes. But then there also has to be an underpin applied, such that in respect of that 15 to 22 service, the member then gets the better of what the old scheme rules would give and what the new scheme rules would give. So again, very briefly, if you look at the NHS, the old scheme is typically called the NHS 1995 scheme. The new scheme is the 2015 scheme. You joined back in 1990 and you're still active today. You would have had service in the old scheme from 1990 until 2015, then in the new scheme from 2015 onwards. That's now been changed, such that, as I said, that period from 15 to 22 has been moved back into the old scheme. And this has, in some cases, it's led to an increase in the benefits that some people have had. In some cases, it hasn't really had much of an impact. In terms of where the schemes are with dealing with this, they were meant to have, all the public sector pension schemes were meant to have had all this sorted by the 1st of October 2023. Some cynics amongst us thought that was always a slightly ambitious timetable, and it did indeed prove to be the case. I am pleased to say the NHS scheme, which is the largest of the public sector schemes, is now issuing McLeod compliant CVs. The civil service scheme is issuing McLeod compliant CVs. The teachers scheme is increasingly issuing McLeod compliant CVs. Police, local government, and firefighters are all administered locally. So the administrators of the Greater Manchester Police scheme, if you like, is different from, say, one in Essex. And I think different parts of the country are in different places with this. I think we've certainly seen every week that passes, it seems that more schemes are issuing CVs on that front. And the only real big one that's left over is the Armed Forces pension scheme, which is, they have got some slightly horrendous issues to deal with, and I don't think they're quite in a position to look at issuing McLeod compliant CVs, although I think some progress is being made there from some stuff I heard on this particular issue. So I think we are suggesting that we're to settle cases, we would really like to see McLeod compliant CEVs. There are workarounds that can be applied where you still only have old CEVs. And certainly if we were to be instructed, we would be able to have a look at them and comment on, are we happy with what we've got here? Or is this one of these cases where we'd say, no, I'm afraid you're going to have to wait and get the final version of CEV because it's just too uncertain as to what's going to happen here. So a bit of a mess, I think, but we are certainly getting there. And I think as the months pass, I think this issue is going to be resolved.
Okay, thank you for that. So different topic now, lifetime allowance. So it was present and very complicated. It was abolished to a significant extent, if not entirely, by the last budget. It looks as though nobody is actively pushing it to come back in at the moment, though you never know. Can we forget about it now, Jonathan, or should we still be worried about it?
Well, if I can be cynical again, the pensions tax laws were changed in 2006. That's when the current regime was brought in 2006. And it was at the time, I was a young trainee actuary then. It was called at the time pension simplification. And we said there's something very, very Orwellian about this. It should really be called pensions complification, if you like, rather than simplification. Yes, so I think it was confirmed that the Shadow Chancellor, Rachel Reeves, has changed her mind and now has no intentions to bring back the lifetime allowance as it was. That is reassuring, I think, given that quite a bit of work was done to explicitly remove it from statute. I think there are a few sort of legacy issues that knock around that might concern the lifetime allowance that do need to be looked at when it comes to divorce, primarily around cash, as the rules were when the lifetime allowance existed, that you could take a tax-free cash lump sum of 25% of your pension, but that was capped at 25% of lifetime allowance, which I think works out at just shy of £269,000. The LTA is gone, but this limit still remains. So that's something that still needs to be considered. If you had protection, there were protections available. If you had protection against the lifetime allowance that give you a larger lifetime allowance, then those protections still carry on. You can enjoy a larger tax-free cash lump sum. And I think this is really quite pertinent when you're looking at pension sharing cases on divorce as to exactly who has which protections, and then that might well drive what the optimal solution is. So and there's another few subtleties around pension sharing when it comes to these protected lifetime allowances that needs to be considered carefully. I think we always said in the past that there were a few opportunities that existed for better utilising parties' lifetime allowances. Often one of the benign consequences of a divorce was the fact that if one party had enormous pensions, the other one didn't, you can make better use of the lifetime allowance. The fact the LTA is gone, I think there's still some stuff around cash that does need to be considered in a bit more detail there. So can we forget about it? In many cases, yes, but there will always be that handful where seeking proper financial planning advice alongside getting a POD report is the right thing to do.
Okay, well, thank you for that. Anyone's using the chat bar, the web link for the Advice Now report is on there. Also, the link for the PAG2 is now on there as well, if you want to make a note of that. I think somebody asked if the citation for SP and AL was on there. I think Reese, you might be putting it on there. There it is, just appeared. SP and AL 2024 EWFC 72, for anyone who'd like to look at that. We will have a session in a few moments for any questions which come up. I think we've dealt with them as we've been going through mostly, but a couple more issues just to tackle. Another one for you, Reese. The pre-action protocol has now come into force in the last couple of weeks, I think. Tell us about that, in particular in the context of pensions.
Yeah, so I'm just turning it up now, and the start of the financial remedies pre-action protocol, which if you haven't seen, it's very important that you read. It's in the annex to the practice direction supporting part 9, and it says this in the introduction: for coming to court, unless there are safety concerns or other good reasons not to do so, the court will expect parties to have attended at least one form of non-court dispute resolution. And in the expanded definition of non-court dispute resolution in the amendments to Part 3 at the end of April, it now includes mediation, arbitration, evaluation, for instance, a private FTR, and collaborative law or collaborative practice. And I think the observation I would have, thinking about the orderly management of cases, if you read the whole of the pre-action protocol, it's expecting people, practitioners, to grow up a bit and to manage some of the things which previously have been managed by the courts. There is no reason in some cases why there cannot be orderly disclosure. Now, I accept entirely that there are those cases where the full solemnity of the law needs to be brought to bear on people who won't cooperate. But there are many cases when, in fact, everyone knows what disclosure is required. It's the Form E. You must reply to reasonable questions about issues in the case, and it may be necessary to instruct experts. One of the things I've been treated to down the years is seeing the furious arguments that have gone on about how an expert, particularly in relation to pensions, is to be instructed. And I think George Matheson has some horror story of parties spending, thousands upon thousands of pounds just bickering about the letter of instruction. And that's really got to stop if you're going to get to non-court dispute resolution before you've issued proceedings. And so what we're looking at is there's a template in the in PAG 2 for how you can instruct an expert, and the guidance by His Honour Judge Hess in SP and AL is very much in favour of the equalisation of income outcome. There are options in the template, but the equalisation of income tends to be the lead way it's approached. And so it seems to me, standing back, once this protocol starts to bed down, we're going to need to be more cooperative and collaborative in the way in which we go about instructing our experts, rather than having these furious bickers over the different tortuous permutations of a letter of instruction. Quite often, less is more so far as the letter of instruction is concerned, that the expert is not going to resolve the case. All the expert is doing is providing some indicative figures, which the judge can then apply Section 25 to. And so it's the judge who decides the case, or the parties, not the expert. And so it's pointless having all these gazillions of different possible permutations and facts thrown at the expert, because they're really not that interested. So I think it'll be interesting to see how the pre-action protocol beds in, and how it alters behaviour in the pre-action space, things that quite often are quite contentious at first appointments. In order to get to your non-court dispute resolution, you might just need to tone it down on the bicker a bit.
Okay. Now, a couple of questions come in about the delay in getting CEs from various pension companies. The teachers' pension and NHS have been specifically mentioned. As one question which perhaps I can answer: is it in order to present a consent order which says we don't know what the CE is, yet we still want you to make that order? I think the answer would be to that. It might well be possible to do that, as long as you present a detailed explanation, explain why it's fair to do that and why there's been a difficulty in actually getting the figure. So, Jonathan, again, are you aware of particular difficulties getting CEs from teachers' pension or NHS pension? Are they more difficult than others?
They shouldn't be. I wouldn't have thought. The NHS scheme, they certainly are now McLeod compliant. I think if they are still holding up CVs, there must be a particular oddity about it, because we see lots of McLeod compliant NHS ones coming through now. Teachers' pension scheme, I think they have only started issuing McLeod compliant CVs in very short order. They are able to produce benefit statements that are McLeod compliant, and I certainly should point out, were we to be instructed in the case and it involved the teachers' pension scheme, then we would probably be happy to work off the back of McLeod compliant benefit statements, and then we'd be able to work out what the CVs would be under those circumstances.
Okay, a couple more questions which I might put to both of them, actually to Rees. Actually, what one is the pre-action protocol law or guidance, and the second question is if a solicitor negotiation has taken place, although it may not formally come in with the within the NCDR definition, is that good enough for allowing the matter to go forward? Rees, do you want to respond to both those questions?
Yeah, so the pre-action protocol is law. It is an annex to the practice direction which supports Part 9, and so I mean, it's a practice direction, and you'll recall, I can't remember the name of the case, but there was a Mumby case some years ago which debated the hierarchy of the rules versus practice direction, and if there's a conflict between the practice direction and the rules, you prefer the rules over the practice direction. But essentially, it is something that's there to be followed. So far as good attempts to resolve matters, the intention in the protocol is not simply for parties to be able to say, well, we've been in correspondence for 18 months and we haven't been able to resolve it. There needs to be something more than just correspondence. The attendance at a round table meeting, often not around a table, but the convening of people at an event, but perhaps without a mediator or a neutral evaluator, is something which has the potential within the protocol to be good enough, providing it can be evidence that there'd been proper disclosure and there'd been a serious attempt at trying to resolve those matters, and it had come to naught.
Yeah. There's another question. Is the Financial Remedies Court now adopting a more robust approach, prepared to make cost orders for party failing to engage in NCDR? Again, perhaps Rees, would you like to comment on how the
I'm very happy. I'm very happy to deal with that, because I am a member of the Family Procedure Rule Committee, so I've watched these rules germinate and come into existence. And whilst the precise discussions within the committee are confidential, I think I can say this, that we have watched the rule change about open negotiations flourish into case law, OG and AG being the lead example of that, where there have been cost consequences. And so when the rule first came out, perhaps people didn't take it as seriously as they might. Oh, it's only in a practice direction, who cares? And then all of a sudden there's cost consequences coming on the back of that, and we've all been to those seminars where we're taken through all of the cases where a failure to negotiate openly has resulted in cost orders being made, and there is now an express amendment to Part 28 that if you unreasonably refuse to attend at non-court dispute resolution, then that is a reason for departing from the no orders to costs presumption. So we'll have to wait and see what case law comes out on the back of that, but it's certainly there in the rule.
Yes. So I'm just going to take up a question from earlier about the signposting. Does the court signpost litigants in person the Advice Now guide? And I'm going to follow that up, but I think the answer is that there is a reference to that in something which goes out to anybody issuing a Form A, and it's also on the government website.
I'm also pleased to say that it's referenced as a resource or rather the suite of Law for Life guides is referenced in the pre-action protocol as well.
Indeed, yes. Okay. Right. Well, we've reached 2 o'clock, so I'm going to have to wind up this session, and no doubt everyone's got lots of work to do for the afternoon. So may I thank all of the panelists, Reese Taylor, Emma Hitchings, Beth Kirkland, and Jonathan Galbraith. I hope you've got something useful out of that session. If you'd like to watch it again, it's going to be available on the FRJ website for some time to come. So thank you very much indeed for all of you attending. I'm going to call the meeting to a halt. Good afternoon to you all.